Good evening. It's 6:31, October 19th. I'd like to call this meeting of the Board of Adjustment to order. Could we get roll, please?
Board Member Primo.
Here.
Vice Chair Jenna.
Present.
Chair Spencer.
Present.
Board Member McClintock.
Present.
Board Member Johnson.
Present.
And Board Member Rychecki is absent tonight.
Thank you. Moving on, our next item on our agenda is approval of the minutes for the August 17th regular meeting.
I'm sorry, Chair Spencer. First approval of the agenda.
Sorry. Correction, approval of the agenda. Do you have any questions? Do I have a motion?
Motion to approve the agenda. Second.
Have any discussion? Seeing none, pull the board, please. We could just move forward. Okay.
You can do just a general, is there anything?
Consensus?
Yeah, general
All in
consensus
favor,
on this.
say aye.
Aye.
Okay.
Agenda approved. So moving on to approval of the minutes of the August 17th regular meeting. Does anybody have any questions on those? Or do we have a motion?
I move to approve, based on the recording secretary's certification, the August 17th, 2017 action minutes for the August 17, 2017 regular meeting for the Wilton Board of Adjustment.
Have a second?
Second.
Have any discussion? No. All right. I'll vote then. -1. You gonna vote?
Member Johnson, you'll need to use the voting board.
He's in the bottom, but he's there. Oh, sorry, they are misaligned. My apologies.
Gonna use that one. Okay.
One more time, please, so I have a clean one for the video. Okay, you're using the wrong one, the one
Okay.
on your left.
That one, okay.
Perfect. That's unanimous. Thank you.
Technical difficulties. All right. So the minutes are approved. Move on to public comment. Is there anybody in the public that signed up to speak? We didn't have anybody signed up when I was up there. Okay, doesn't look. Is there anybody who's not signed up who'd like to speak? Seeing none, we'll move on to our general business for the evening. And I'd like to just start out by having a brief statement by the city attorney.
Thank you, Chair Spencer. I just want to give a brief statement on the arrangement tonight. It is a bit unique. So we're here to see an appeal of a zoning decision. Lena McClellan, as usual, city attorney, helped advise staff on that decision, and therefore there was a conflict of interest for her representing the board. So therefore, tonight I am representing the board, and any questions the board has will be directed to me and not to Lena. So,
Okay.
thank you.
Thank you very much. So the first item is case VAR 17-0008, an appeal to planning staff's notice of determination pertaining to the screening for San Miguel LLC's parking lot located at 8000 South Parkway. I'd like to call staff forward. Ms. Hall?
Hi, for the record, I'm Pam Hall, planner for the City of Attorney. Before I start my presentation, I would like to ask if I can include an exhibit that was sent to all the board members and the attorneys yesterday as part of the packet.
Just please give a copy to the applicant before presenting it to the board.
Yes, sir.
And you may give it to the board as well.
So tonight we have before us variance and appeal for planning staff's notice of determination for screening at 8,000 South Parkway. So the additional exhibit that I had emailed was part of the, as part of the packet, has been included and passed out. Oops. So what this was concept meeting notes. We held a concept meeting with Dale Eubank on December 1st, 2016, and there were notes included requiring screening as part of this concept meeting. San Miguel purchased the property on December 16th, 2016. Previously, that parking lot had been used as an employee parking lot. So Mr. Eubank wishes to use an existing chain link fence for his new use of storing cars and claims that the existing fence is a non-conforming structure and provides sufficient screening. The chain link fence is located along the property line and also has barbed wire on the top, which is not allowed in this planned development industrial zone district. Mr. Eubank's position is that the use has not significantly changed and that the isolated location of the property should be taken into consideration. The site is currently being used for new car dealership inventory and large profile vehicle storage. So on July 25th, 2017, staff sent Mr. Eubank a notice of determination to San Miguel requiring screening for his new use. A copy of this notice was provided as an attachment to your packet, and the notice states that the City of Littleton zoning ordinance does not require any fencing for employee parking lots. However, the City of Littleton zoning ordinance does require screening around all outdoor storage. When Mr. Eubank purchased the parking lot on December of 2016 and started leasing the lot for storage of motor vehicles, he changed the use, and the new use needs to comply with all zoning requirements. Specifically, it was determined that the lot needs to be fully screened because of this new use. So 10-4-7A, which is on the board, states that all outdoor storage, including but not limited to the facilities for building materials, raw materials, equipment, scrap, trash, and products, shall be enclosed by fences, walls, and/or landscaping which fully conceals such facilities from adjacent properties as viewed from ground level. There are no provisions in this code to give any consideration for an isolated location. Additionally, the barbed wire material needs to be removed at this location because 10-4-3A6B states that barbed wire fences shall be permitted only in A1, RS, and RL zone districts and shall be installed at least no less than 5 feet from any property line. It is the city's position that the non-conforming section of the zoning ordinance does not apply as there is a new use being added, and the new use needs to comply with the above sections of the code. The non-conforming section is found in 10-10-2A. A non-conforming structure may be occupied, operated, or maintained. Enlargement. Non-conforming structures should not be enlarged or extended with all the applicable requirements of the code, and then see if there's any termination of the use. So Mr. Eubank was also directed he was also directed to screen this, and he was given a date as needed to be provided by Friday, September 30th of 2017. Otherwise, all the vehicles needed to be removed from the premises. Mr. Eubank provided a response and has appealed staff's determination, which was outlined in his application. The applicant states that the use has not significantly changed. It's the city's position that there's a significant change from employee parking lot to storing vehicles overnight for a period of a few days to 3 or 4 weeks. So the City Code 7-4-9 states as follows about derelict or unlicensed vehicles, that it should be unlawful for any person to store, maintain, or keep any derelict vehicle or unlicensed vehicle as defined in this chapter on any private or public property or public rights-of-way of the city. Shall be unlawful for any owner or manager of real property to permit or allow storage, maintenance, or keeping of any such derelict or unlicensed vehicle on real property, public or private, or in the right-of-way when the city uses its procedures in this sections 743 through 748 of this chapter. There are 3 exceptions, and they are as follows. There's a residential zone district exception, a vehicle sales or storage lot, and then the commercial or industrial zone districts, which that particular exception says in a fully enclosed structure or in the area located behind the principal structure, and they need to be screened from view of adjacent properties at any right-of-way. Inventory vehicles are not licensed, and they need to comply with 10-4-9B of what I just read to you by keeping them inside a fully enclosed structure or screening them from view of adjacent properties and any public right-of-way. So the applicant states that requiring the replacement of this fence would not serve the purposes of the code and would achieve no benefit to adjacent properties. It's the city's position that the chain link fence must be replaced with a solid fence or other screening materials in accordance with 10-4-7. So as part of this process, the Board of Adjustment has an authority to hear appeals through the city portion 10-11-1A. And there's 3 criteria regarding that. The board shall hear and decide appeals when it's alleged that there is an error of any order, requirement, decision, or determination made by the city in the administration of this title. The board may reverse or affirm, wholly or partially, and may modify the order, requirement, decision, or determination as ought to be made, and to that end shall have the power of the officer or department from whom the appeal is taken. So you need to have a concurring vote of 3 board members, which we have 5 and we have our quorum, but 3 board members are necessary to reverse or modify the order. And then the appeal from the order, requirement, decision, or determination made by the city shall stay until all proceedings in which the zoning official certifies such stay would cause, unless it would cause imminent peril of life or property. So in this case, the city has stayed enforcement of requiring the removal of the vehicles or constructing of the fence until the decision from the Board of Adjustment tonight.
Thank you, Ms. Hall.
Okay. We do have a recommendation that the chain link fence does not provide adequate screening, that a solid fence or landscaping must be provided per the section in the code, and the barbed wire needs to be removed. So does the board have any questions of staff?
Yes, please. One question. Did you say that the concept meeting request did say that the property needed to be, that the fence needed to be screened?
That the parking lot needed to be screened to do the use that he had intended, yes.
Could you just point me
The
to where
page,
that
sure,
was?
just a second.
Thank you.
Okay, it says page 3, but it's like page 6. And there's a big box and it says planning notes. And it talks about mini storage of the gates portion of the site. But on down further, it talks about parking, open space, screening, and setbacks all need to be met on the lot. And I believe there was one other piece. Oh, the next sentence. On the existing mini warehousing site, the outdoor storage parking of off-site vehicles, cars, vehicles is not permitted under the existing PD and pursuant to the definition of commercial parking of the city zoning. So we had worked with him about screening the parking lot as opposed to amending the plan development plan.
Thank you.
I've got a question, just for some clarification. You made a point about derelict vehicles and, unlicensed vehicles and stuff like that. It would seem to me that based on at least that concern, there are a lot of automobile dealerships that don't have fences around them, yet they leave cars in the front of their dealerships. And
For demolitions, is that what you said?
no,
Displays for the new car dealers?
right, and
That's
used
part
car-
of their
used
site
car-
development plan when they do that. So
Okay.
it needs to be a sales on the property, on the lot. And then that was one of those exceptions that I did not read. Okay, so C of 749 talks about vehicle sales or storage lots. So in a vehicle sales and storage lot, when they have been zoned for storage or keeping of derelict or unlicensed vehicle. So it's part of the car dealership and part of their site development plan as to what needs to be screened and what can be displayed. This has no sales on this lot that we're talking about. It's for storage only. Storage of vehicles only.
Okay, and if this was just a pay to park
Like an
facility?
employee lot?
No, just a regular commercial, like if you go downtown and, you're trying to get into a Broncos game or you're trying to get into, Coors Field or something like that, and there's a parking lot there that you have, you pay, $10 a day or, $20 an hour in some cases. What's the difference between that and what's currently, it's the determination as to how long the individual or the vehicle stays is pretty much up to the customer.
Well, there's a couple differences. The first one is when you go into a public parking area, there's requirements in our code that does have screening, and it talks about different types of fencing, landscaping, or walls to screen. So there's requirements in our code for public parking lots. And then also the difference between a regular employee lot or a lot where you stay for the day versus what's occurring at 8000 South Parkway is these cars are staying from anywhere from 3 days to several weeks or, possibly a month or more. So they're staying for 24 hours a day.
Okay, but it's still the at the discretion and the decision of the customer, not from the property owner.
Well, that may be the case, but then in different cases where the use is a long-term use, we require screening in our code.
Okay, so is there an area that is exclusively for long-term, or is it just kind of helter-skelter throughout the entire parking lot?
This particular lot?
Yeah.
From what I had seen, but it's been several days from when I've been down there, it is all parked in, regular spaces. They're not helter-skelter because they're trying to fit as many vehicles as possible into that. However, there is no screening for that site.
Again, I go back to that screening requirement for a pay for parking facility. What kind of screening is required for that as compared to what you're recommending for this?
Well, for storage only, we're recommended solid seat screening, and it's also in the plan development plan for gates. Is that correct, Kara?
There's a requirement for screening in the PD and also in 1057A3 of the city's zoning regulations that requires that parking lots be screened. And there's parameters and structures such as walls or fences are used to create a screen. Plants may be located on the sides of the structure, which are visible from adjacent rights-of-way. And this is a requirement for all zone districts throughout the city.
Okay, well, assuming that we go with screening material, it sounds to me like you've selected what kind of material or requirement that's going to be required to do the screening, making it a solid wall or a solid...
That was one of the choices. There were several choices that could happen. You needed a solid fence, landscaping that would sufficiently screen, or a wall. So there were several different types of screening that would be available.
Okay, because I'm thinking that with a chain link fence, you can probably get chain link with some type of infused material that would provide, visual screening rather than a solid wall.
So the slats, is that what you're proposing? I'm not sure what you're talking about material.
Okay, you've got chain link fences that have got sliding pieces of material that go through the links. It sounds to me like that hasn't been considered, or has it, or is something that you've determined that's not within in your preference.
Yes, so the city has historically not allowed those slats due to a number of reasons. One, they're difficult to maintain and they become unsightly very quickly. Canvas material over the front of the fences has also not been permitted. There's nothing specifically in the code that precludes it. However, it's been our historical practice not to allow that as a fencing and screening option.
Okay, so basically what you're saying is that it's just historically not been used.
And not permitted.
But it's not permitted.
Correct.
It's
It's not prohibited, but it has been historically not allowed.
Okay, but it's been based on historical precedents.
Yes,
Okay, but no requirement.
correct.
Okay.
Do we have a copy of the PD?
Yes, we do. Only one copy.
Isn't it in your?
Well, it's actually part of the applicant's application. He had exhibits on there.
The written portion.
The written
Correct.
portion of the PD, yes.
Okay.
So this was an anomaly, this PD. There's, I think, 2 of them in the city where the covenants for the area were actually adopted by the city and they serve as the PD. So the language in there talks about uses but it was recorded as if it was a PD. So
Okay.
the covenants in there talk about what has been done and what will be done. So there's portions in there that talk about all developments and then specific lots. And but there's one other one that's also been done that way, and we won't do that again.
That was a while ago.
Yeah, it was a long time ago.
It was in the 50s, I believe.
So I believe there's a section in there, the amendments to the declaration of planned industrial park uses. That's part of it, where it lists permitted uses. And you're stating that there's a whole string of 18 plus uses in there. There are no sales on this property, correct? It's just leased, subletted storage, essentially.
That's
Of the
what
vehicles.
we've been told, correct.
Okay. And there is a use in there listed as parking of motor vehicles. And then there's a warehousing of raw materials or finished goods, which is not specific to vehicles yet. It reads somewhat like 10.4.7a, where it's including but not limited to, and then it lists, building materials, raw materials, equipment, scrap, trash, and products shall be enclosed by fences, walls, or landscaping. That's one item that's cited by staff. Is it the products that are part of staff's determination in that particular section of code?
Yes, the products.
Okay. Because some of those other ones make sense, but That would be the only one that I could find that might be
Correct.
applicable in this case.
And that's only one section of the multiple sections of
Correct.
code that talked about screening.
Okay. I just wanted to clarify the PD section. Typically, there's an exhibit that goes along with it and the like, so I just wanted to verify that.
Right.
Okay, I will pass it along.
I had a question on common fences. Are there common fences with this property compared to their neighbors to the east, the CenturyLink, for example? Is that a common fence?
I don't believe there's a common fence between them, but I'm not 100% sure. I'm sure they could speak to that.
Okay. And then which begs the question about who would be responsible for the common fence? How do we determine?
Well, if it's CenturyLink, it would be employee parking, and employee parking does not require any type of screening at all. No fencing, no screening.
Depends which way you're looking, right?
Right. And how long those vehicles are there.
And when you mentioned about licensed cars, if you're talking about a temporary tag for a dealership kind of thing, does that constitute a licensed car?
It would, however, in most cases when vehicles are stored on the lots, they do not have any plates on them.
Okay.
But the only reason why they would have a plate on was that they need to be able to move it. So therefore, it really is licensed. It's just a matter of not having the plate itself on the vehicle, because it's a kind of a general license for all the vehicles that are owned by the dealer.
But at the time when they're being stored, they do not have, like they could not be, you could not get into the vehicle and drive it onto the street without placing a plate on the vehicle.
Right. So it's just a matter of having the plate. It's not the fact that it's not licensed.
I wasn't saying they were defective or anything, no. So they're not a derelict vehicle, they're just unlicensed at the point and they're being stored.
That's my point. They are licensed. They just don't have a license plate on it.
Correct.
Correct. Okay.
Well, they're licensed to the dealership possibly.
Right.
Yes.
Exactly. So that I think part of that discussion with regard to licensing doesn't apply.
Okay, there's still the storage piece. There's other pieces to it.
But again, storage is based on the owner's decision rather than that of the real estate owner or the parking facilities owner.
Well, like I said, for any of the dealerships that we do, we have certain areas that are allowed to have displays and then certain areas that they're allowed to store inventory. This particular lot was an employee lot historically, and it has not come in for any type of process to go through and work through any of these problems or solutions to be able to provide that service on this. It's a new use, so to provide the service on this lot.
And it is off-site storage. The difference between the car dealerships all up and down Broadway is that they're storing their vehicles on-site, the ones that you see. These are vehicles that are stored off-site. They're not selling the vehicles here. They're stored overnight, long period of time on this property. Large profile vehicles are also being stored. And they're I don't know what page it's on. We have no pages in this thing, but it's number 8 in the covenants. Paragraph 11 is hereby amended in its entirety. Temporary open storage of equipment or materials shall as much as possible be at a considerable distance from the front side and rear setbacks and screened by fencing and or landscaping.
Yeah,
So it is in the
is
PD.
it storage or is it just parking?
This is considered storage of vehicles because they're not parking vehicles that are, it's the use is on, so if this was a business and somebody was operating the business there and these employees were coming to the business, that would be vehicle parking. This is storage, the use, it's a separation of the use. This is off-site storage of vehicles.
Okay, now you mentioned that there's a process that hasn't been gone through with regard to trying to characterize the property.
Right. There was no site development plan or sketch plan or any process to go through a planning process to allow this type of use. So if we could have gone through a process and provided screening or, worked on some sort of resolution on how to use this use, but that was never done.
Okay, is that because the owner opted not to do that, or is that something that
Correct.
just never occurred? Or is that
No, that was part of the concept meeting as to how to proceed with what he wanted to do on this property.
And that was outlined in the exhibit
Correct. That was the exhibit that was emailed and I was passed out.
meeting? Okay.
Okay. That one I hadn't seen until now.
Any other questions for staff?
Any other questions? All right.
All right, thank you.
Thank you very much. I believe the owner is here, or his representative. Please introduce yourself, state your name and address for the record, please.
My name is Dale Eubank. I'm the owner of the LLC that owns the property. I live in Carbondale, Colorado. And this is my attorney, Mike Sawyer.
Thank you, Dale. We appreciate the Board of Adjustment taking.
Could you state your name and
Yes, of
address
course.
for the
My
record,
name's-
please?
yeah, of course. My name is Mike Sawyer. I'm an attorney with the law firm of Karp New Hanlon out of Glenwood Springs. Again, appreciate the opportunity to make a presentation in front of the Board of Adjustment. I do want to ask a quick clarifying question. The page that's shown up on the screen here has two concepts in it. The first, it says variance, and then it says appeal to planning staff's notice of determination.
This is an appeal process.
This is an appeal. But
Right, correct.
This is not a variance.
Correct. This is an
process.
appeal of a zoning determination where the board is reviewing basically whether the zoning administrator's determination was supported by substantial evidence.
Great, thank you, thank you. I would like to provide a little bit of context in terms of where this property is at. I understand that from a zoning standpoint, the code and the PUD says what it says, and we're going to talk a little bit about why we believe it dictates a different result than the interpretation that your staff has made. But I do think it's important to understand where this property is and how it relates to an adjoining property that is referenced in the exhibit that was provided to you today. So Mr. Eubank purchased this property in December of 2016. The property in question I've outlined in pink here. I don't know if you can see on this exhibit.
Can we move this a little
Sure.
more towards you, just so we can get it on the record for the video?
Tell me when.
I think that's good. And upstairs, if you can't see it, just let us know.
Actually, our producer said that he has the camera zoomed in on it. The question is, can our board members see it okay?
No, I'd like to be able to make some
Right.
references with the pointer, but it can sit wherever you all would like.
Can,
And there's
can
a
you
printed
all
exhibit of this as well,
see
correct?
it?
You can refer to?
This is off your GIS system. I printed this off today, and I'm happy to leave you with a cardboard copy. So you have that for your record.
That'd be great, thank you.
I believe it's pretty much Exhibit C, or very much like that.
Very similar.
Close enough, yeah.
So, yeah, if we need clarification, we can ask you to bring it forward. Thank you.
Okay, thank you.
So again, this property is located in between Mineral Avenue and South Park Drive. You will note that it is not contiguous with any public rights-of-way. Again, the history of this area, the Gates Rubber Plant used to sit down here. It was, as part of a redevelopment, I think in the late 70s, revamped for certain business park, quasi-industrial uses. And somehow this particular parcel, which fits within this Gates PUD, ended up not having any frontage. In 2016, December of 2016, Mr. Eubank purchased this parcel, the one that has no public right-of-way frontage, together with this adjoining parcel here over on South Park Way. And the reason that I want that distinction to be made is that when you reference the exhibit of the pre-application meeting that was handed out today, there are certain discussions about what the applicant intended to occur on the South Park Way property, which falls under a different zoning regime, i.e. the South Park PUD. And then there's a separate discussion for what he intended to occur within the Gates Rubber PUD. And what he had requested in the Gates Rubber PUD was to discuss putting drive-up mini storage on this property. And the discussion about additional car parking or car storage was actually in reference to the property that fronts South Park Way. And it's worth noting that when he purchased the property, this land had already been leased for these cars parking activities with the current tenant of the property. So I say that just by way of clarification for one of the exhibits that was passed out, and also so that you can see that, you know, this parcel is by and large a large parking lot, and what surrounds it is mostly other parking lots. So we've got 2 parking lots related to the CenturyLink property. We've got a large parking lot related to the Lockheed Martin property, which my client owns, and then other ancillary parking lots that surround buildings that directly adjoin the property in question. What we're really talking about with regard to this appeal is what's going on in this property parking, or is it storage? And we believe that what's going on this property is in fact parking. The land use on the parcel in question really is dictated primarily by the text and language in the PUD. And if you have in your packet the copy of the PUD, I think it has a sticker that says Exhibit A on it, and go to the 4th page in, up at the right-hand corner. It says Book 7604, page 275, and this had been referenced by one of the members of the Board of Adjustment. Parking of motor vehicles is specifically called out within the zoning as a separate use by right. It is important to note, because staff has made the point that they believe that this property was historically used for parking ancillary for employees to adjoining buildings, that while at certain points in the history of this property that was the case, in terms of the zoning doesn't make that type of distinction between uses by right. It says parking of motor vehicles. It does not say parking of motor vehicles for purposes of employee parking. It simply says parking of motor vehicles. And we believe that this is important for determining what can be done on this property, and that what occurs here is, in fact, parking as opposed to storage. As we noted in our appeal letter, the town of Littleton, at least that I could find in the zoning code, does not have a definition of parking by itself. But the town or the city has adopted the model traffic code. And the model traffic code does have a definition of parking, and that is that it's a temporary standing of a motor vehicle is what constitutes parking. Nothing in terms of the definition of parking in the model traffic code, or what you would find in your common dictionary, indicates that parking needs to be adjacent to some other land use. It simply is the standing of a motor vehicle for some period of time. Therefore, we agree, or we disagree with staff that this is a storage use as opposed to a parking use. The staff has brought up your code section 7-4-9, which relates to unlicensed and derelict vehicles. And they have cited you to subsection B, that they can occur there in commercial or industrial zone districts in a fully enclosed structure or in an area located behind the principal structure. I would actually assert that the appropriate provision in section 7-4-9 that you should be referring to is C, vehicle sales or storage lots. In vehicle sales or storage lots when the same have been zoned for storage or keeping of derelict or unlicensed vehicles. And again, going back to the PUD for the Gates property here, it specifically says parking of motor vehicles. It doesn't have any reference to whether they're licensed or unlicensed. It simply says that you have the right, a use by right, to park motor vehicles on the property. With regard to the fence, we believe that it has the right to stay in its current configuration. A question was asked whether these are boundary fences that are coming into play, and the answer is yes. These fences are located here along the western boundary and then here along the northern boundary with CenturyLink. Those fences have been there as far as we could go back and find some photographic evidence, at least to 1993. They've probably been there much longer than that, and one of them may have been there since the Gate rubber plant was there. Under the zoning code, because this is parking and not storage, this is not a new or intensified use. This is merely a continuation of the exact same use that has occurred on this property for 30 plus years, parking. We included a couple of photographs, historic aerial photographs showing the parking use going back in time. Because the use is the same and is permitted by the zoning, whether it is used adjunct to employment and use of an adjoining building or not, there is no change of use to trigger a termination of the pre-existing non-conforming nature of the fence. Further, we believe that the section quoted by the staff related to the barbed wire on the fence is inapplicable to this property. If you go to, let's see, section 10-4-3 in your code, you will note that it says fencing in residential zone districts. And the specific provision referenced by your staff, which says that barbed wire can be in 3 different zone districts, are all residential zone districts. This is not a residential zone district. This provision of your code simply does not apply to this piece of property. So, again, we believe that parking is a use by right, that what occurs on the property is in fact parking and not storage. They are vehicles, they are in running condition, these are not junked out vehicles, this is not a junkyard. They are parked on the property for periods of time from 3 days to 3 or 4 weeks, and then they get turned on and they drive away. That is the quintessential definition of parking. As such, you have a use allowed by the zoning. You have a parking use, not a storage use, therefore screening is not required. And finally, because it is a continuation of a pre-existing use as opposed to an intensification or new use, the termination of the pre-existing non-conforming fence is not triggered. So, you sit here, you're being asked by this applicant to overturn a determination of your staff. You should not do that lightly. Part of my practice is actually I represent a couple of small municipalities, and I believe that it is important to support staff when that action can be taken. However, situations arise where differences of opinion about the interpretation of a code can occur. And I believe that this particular situation, that there has been at least one misapplication of one of your code provisions, and that in light of the separate designated use of parking of motorized vehicles in the zoning code, really militates towards overturning the staff's interpretation that they have made. Boards of adjustment are also often concerned about setting a precedent, even though variances or staff determination appeals are generally not deemed as having precedential value. And therefore, I want you to think and consider that in this situation, you do not need to have too much worry about making a decision that will have wide-ranging applicability across Littleton. And the reason is that parking of motor vehicles as a separate use by right is really unique to one place in your town, the former Gates property. And that you're looking to that zone language and making the common sense interpretation that this is parking and not storage will have a very limited application beyond the boundaries of this PUD, and in particular beyond the boundaries of this very isolated, non-visible spot within that PUD. We thank you for your time. We would appreciate your support in allowing the parking use on this property to continue in a similar manner as it has for many decades. Thank you. If you have any questions, I'm happy to answer them.
Thank you very much. I just had a quick question. What was the intent, I guess, if this pre-application meeting occurred in November, and some of these uses were delineated on this exhibit here? And I apologize, I just got this today. I did not receive the email prior, so I'm just digesting some of this. But I guess what was the intent in here with presenting this exhibit if the applicant was just going to purchase the property? He designates some areas on here as proposed vehicle lease parking, and vehicle drive-up storage. That, I think staff mentioned about the drive-up storage, and that's really the location that we're talking about as vehicle lease parking. It is also listed on here. I guess my question is, I'm unclear why there would be a pre-application meeting if it was a simple transfer of property versus an intent to develop or redevelop.
There is an intent at some point to redevelop this property as drive-up mini storage. And that was part of the pre-application meeting that was discussed back in November, was, what the criteria would be and, what concerns there would be for drive-up mini storage on this site. Again, as I indicated, at the time that pre-application conference occurred, this property had already been leased by the current tenant, and they were already parking cars out there for several months at that point. The reason that there is a mention of additional parking storage activities in that pre-application meeting relates to this area right here. This building, which used to be part of the Lockheed Martin complex out there, is now extra space storage. As you might understand, the amount of parking required by customers of storage facilities is rather sparse. And so my client was interested in finding an additional use for a lot of excess parking on this other parcel. This is in a different zoning regime, and it did require going in and having a pre-application meeting to discuss what are the criteria under that particular PUD to allow for additional parking on this property. And in fact, that application has been processed, and there is now parking and some additional screening that's going to go in on that lot. So that's why there's that discussion in the materials that was submitted to you.
Okay.
I had a question. When I was out there and looked at the property, I could see a lot of typical passenger cars, and then there's a lot of big equipment, heavy machinery in its own separate area. It seemed to be fenced in its own area. I could see the cars move around and see people get in the cars drive away, cars come in, cars go out, but I was curious as to that large equipment that sits out there.
There is an isolated area over here that is separately fenced, and that equipment is used, in fact, in conjunction with the Lockheed Martin is this building here. And so they have, as part of their operation, certain equipment that they then use with some frequency, and it's maintained in that separate area. But the bulk
Saying it's not part of 8,000, or it is?
It is a small part of the area on the Gates Rubber property, but it's this little corner up
Right.
here. And that is used in conjunction with the adjoining building down here.
How would they use that? That's big equipment, big.
I think Lockheed is a military company, and
So it's leased to, I'm confused though about, Lockheed is leasing that property to store that equipment there?
Lockheed
storing that equipment?
has a lease on this small corner that you witnessed when you were out on the property.
So they're storing the equipment there?
I don't know what they're doing. I know that they use that equipment in conjunction with their operations in this building.
The property itself looks like it's really kind of geared to be, it's cordoned off, and really the fencing and I guess the barbed wire, for whatever it's worth, that single strand, I suppose is supposed to provide some extra security. You've got, access gates getting in and out, and to be able to gain access to the property itself. And you have that, you have the barbed wire, I guess, to provide some security. With the recommendation of the staff, what kind of security type of fencing would be adequate to provide the security that you expect to have, or at least that you would be kind of replacing if you put in some type of other fencing material?
I'm not sure that we're prepared to answer that question today. Again, the fence, including the barbed wire, we believe is pre-existing non-conforming, and our belief is it should simply be allowed to stay. Depending on the outcome of this board's deliberations today, we may be back discussing this issue further with your staff, looking at what options are available, and in fact may be coming back to you asking for a variance from whatever code provisions or requirements they think we need to implement. But again, our position is that as of today, the fences that are out there, including the barbed wire, have been there since a period before the fencing regulations were enacted. And again, as I noted in my presentation, I think the provision in the code referenced by staff about barbed wire fencing is limited to residential zone districts, and this is not a residential zone district.
Thank So you're, excuse me, so you are open to discuss the fence material and the fencing concept somewhere down the line, should that become important?
Well, certainly if, and again, I think as the materials pointed out, or that were handed out today, make clear, my client does have a desire to eventually change the land use on this property. And when that happens, there will have to be compliance with, all of the city codes at that point in time, including fencing. And so, again, our belief is that the fencing that exists today should be allowed to stay in its current configuration, but based upon the outcome of your deliberations, we may in fact need to go in and have a substantive discussion with staff about what would work on that site.
Okay, thank you.
I have a question for you.
Yes.
This area where the cars are sitting right now, was the intent to put drive-in storage in there? Like a regular storage lot? Because there's only so much area for cars, and there's a big open space, too.
Yes. I think that is part of my client's consideration is there is this area over here that at the current time is unutilized. Exactly, he has not submitted any kind of application to the city at the current time. He did want to, as part of his purchase due diligence, that was what was the impetus for having the meeting that resulted in the memo that was handed out. He wanted to go in and talk to the city about some ideas he had running around in his head, one of which is some drive-up mini storage, again, within the Gates rubber parcel. That may happen at some point. I don't know that he has a definitive timeline as to when he would be coming to the city with a formal request.
Okay.
Have you or your client investigated any of the costs for replacing the fencing or even taking down the barbed wire, if that's even feasible, just so you can kind of understand what the impact would be?
If it was as simple as snipping off the barbed wire, that's probably a pretty cheap fix. If we're talking about screening the entirety of this lot, that's several acres. I'm not a fencing person, but occasionally I would think with a solid paneled fence, you'd be looking at tens of thousands of dollars, maybe $100,000. It's not a cheap fix.
Thank you.
Other questions for the applicant at this time?
I had a question on this photograph, and I'm not sure who to address the question to. There's some blue lines in here delineating something that seem to go down through the middle of this property. It's
Exhibit,
sure how to
is that,
reference
it's not
I see an
C.
exhibit number on it.
I
Says
think
on the top,
I believe that's a
8,000
staff prepared exhibit.
16002.
Those are parcel lines from the assessor's page. Those, this property has a number of issues. It is unplatted, so any building permits would require platting of the property. And over the years, applicants have come in and just recorded things over at the county. So these are not legal lots of record. So these are just parcel lines on the assessor's page.
Okay, thank you.
I did have one other question. I thought I heard Pam maybe say that the cars that have been there do not have any license plates, but I think the attorney's written statements that they do have license plates.
And I appreciate you bringing that up. So it's a mixture. Some of the cars do actually have license plates, but Pam is correct. There are a number of vehicles that cycle through that lot that do not. And I'm not a car lawyer, whatever that would be. Not an expert in how that licensing works, but there had been some discussion about kind of general dealership licensing, and that sounds consistent with how that scheme would work, at least in my head. So,
Thank you.
Any other questions of the applicant at this time? All right.
Thank you very much.
Is there anybody here, I didn't see anybody in the sign-up sheet, but is there anybody here to speak
Chairman, this is general business, and so under the change of rules, generally, we do not do public
There is
comment.
no
in general
public
business.
comment.
The opportunity to do public comment was earlier in the day,
Okay,
and no one was signed up, so we're past that point.
okay. Well, I guess at this point,
I was just going to ask if this, we heard a little bit about this setting precedents about tonight. Are we going to set precedents or no? We don't set precedents?
I think once we close any questions of staff or the applicant, I'll be happy to address a few points of order about the legal standard here.
Good, thank you.
I had a couple more items that kind of crept up in review of the PD. Throughout it, there's mention of a development review committee. Is that even in existence at this point?
The Development Review Committee was removed from the zoning regulations many years ago.
Okay.
That's the way it is now for council.
Was it replaced by anything?
No, it was not replaced by anything. It's just all done through staff review and in adherence with the code.
So basically, it's been supplanted by staff review then?
The Development Review Committee was made up of staff. It was just, it was director level, and so now it is just done through the regular requirements of the code as outlined in 10.1 and 10.2 in the process section of the code.
What was the question? Sorry.
The question was with regards to the Development Review Committee. That was the original question that was mentioned in the PD.
That's a question for staff.
Yes. Yeah. Or we can still continue.
Yeah, at this
asking
time, you
questions
can
at this
question
point.
the staff or the applicant, but once the questioning has ended and you're ready to enter deliberations, there'll be no further questionings because this is an adversarial process.
Yep.
And then I will be making a few points of order about the legal standard, and
Okay.
then motions will be entertained at that time.
Okay.
So
Thank
in
you.
response to that, in 10.1.8, the Development Review Committee was removed in 2012. In section 10.1.8 of the code, it was taken out.
Thank you. Do you have any other questions of staff or the applicant at this time? All right, I think at this point we will close this portion of the public hearing and open it up for deliberation.
The general business.
Sorry, the general business.
Before we begin, I want to make a few points of order. As to the legal standard, some of the questions have been raised for legal counsel, and a few other things I think that should be mentioned. First, what we're here for today, and there's been some confusion on this, is an appeal of a zoning determination by the zoning administrator. In this case, that's the planning department. So what you are tasked with determining today is whether that zoning determination was supported by substantial evidence, whether it's in accordance with the record and reasonable, or whether it was arbitrary and capricious and not supported by the record. That's what we're here to determine today. And the scope of your determination should be limited to the record, the evidence you've heard here today, in making that determination. Second, as to the precedential effect of this determination, it is correct that there is no precedential effect of determinations by a Board of Adjustment or Planning Commission or any other lower level quasi-judicial body. So that's another point. A third point I wanted to mention is that the model traffic code was mentioned at one point. I just want to point out that that is an instructive and a persuasive authority. You can consider it as a potential definition for parking, but it's not a binding authority. It's not controlling. Because this is part of the zoning code, that the model traffic code applies to a different part of the code. So just to point out on that as well.
So just to clarify, any decision that's made today, it could be appealed
Yes.
further in the courts?
It would be appealed to a district court of competent jurisdiction, Arapahoe County District Court.
Okay. Do we have any other questions for council at this time? Oh, all right. I think we open it up for discussion amongst the board. Guess I can start off here. This one definitely is unique in the fact that the location of the property, some of the intended uses, the PD as it's currently written.
Chair, before we
Yes.
begin deliberations, is there a motion on the floor in which to begin the deliberations?
Do we have a motion?
And I move that we start deliberations.
I think
I
we need
think
to have
we need
a
a motion to either approve or deny a second, and then we'll begin deliberations. And I just note this is a part of confusion for many boards and councils. Just because a motion is brought by you doesn't tie you to that decision. It just allows, once something is on the floor, then we can deliberate under Robert's rules. And there are sample motions in your packet as well if we need some place to start.
Okay. Okay, but that already had this motion.
Well, these are the different motions that we can
Okay.
use. There's basically four options. Do you want to move?
Yeah, I move to continue the public hearing of variance 170008 concerning parking lot at 8000 South Parkway to next meeting, whatever schedule that date that is.
Motion to continue?
Okay.
To a date certain?
Right.
To the next, I don't know what do you have the next regular meeting of?
Probably not November 23rd.
No, that's
So,
Thanksgiving.
so the motion on the floor is to continue to November 23rd? Is that correct?
It would be
would not.
November 16th. November 23rd is Thanksgiving.
Thanksgiving, right.
Okay. November 16th.
November 16th, in order to give all parties an opportunity to kind of regroup and try to get a better feel for what real requirements there are that truly affect this property.
Is there a second?
I'll second it.
Okay, we've got a motion and a second. We'll open it up for discussion on the continuation.
And I would just, before we start deliberations, I would just remind the board what's before it today, which is determination of the zoning determination, whether or not that is appropriate or not, or whether it should be denied. So with that, deliberations are open.
Sorry, one question. For our deliberation,
Yes.
are we limited to deliberating or discussing the motion specifically?
Yes, the motion
versus
is on the floor.
Overall question?
The motion that is on the floor.
I guess I'll start. So we have a motion to continue to November 16th in order to, I guess, visit the facts a little bit more to determine whether or not the determination that was made by staff to either uphold or reverse that motion. I guess I would say that we probably could resolve this tonight. I think there is sufficient evidence that's been provided, both sides. We have the PD, we have staff's interpretation of what they view as storage versus parking. We have the applicant's argument on that point as well. We have the code sections in front of us, at least most of them, that provide the backup for those decisions, and the PD. I think the biggest decision right now is, is the code clear enough for us to make that decision? And I would argue that the PD is clear, but not necessarily the code as it has been argued. And so I think I would support more discussion tonight and a motion to either approve or deny or uphold or reverse staff's decision on this.
You know, I tend to agree with the new material that some folks hadn't seen till perhaps yesterday or today. The concept meeting request would be the new material that's been the newer material. And to your point, I think we can understand the PD and the zoning and the presentations, and I think we could be in a position to move ahead and make a determination tonight.
Okay, my point is that I think that if we allowed the parties to regroup and to start, you know, again, not necessarily again, but at least to listen to each other with a little more understanding, there might be a better accommodation, and this appeal would probably go away.
I would just say the determination of the staff has been made. It's a finality in the administrative process on that side of the house. So in order for there to be a change in this proceeding to make it moot, if you would, that determination would have to be withdrawn by staff.
And what you're saying is that tonight they are not going to do that?
I can't speak for staff. I represent the board, not staff, but I just want you to know what you're asking for.
Mm-hmm.
I guess I would second what council's saying. I believe they have made the determination. Obviously, there's been quite a bit of deliberation within the department. I'm sure all of staff was involved in probably going through these documents and making this determination. I would doubt that they would reverse that. You guys have any more discussion on the continuation?
I would say I'm in favor of continuing to deliberate on approving or denying the overall request and trying to wrap this up tonight. I think the information that's been presented is very useful and kind of helps inform a good decision. And I think with the time we've spent tonight listening to the city and the applicant, I feel like we could make a good decision.
Do we have any more discussion, or do we want to have a vote? And I guess our vote would be on, a yes would be to continue, and a no would be to not continue and go for another motion and more deliberation.
That's correct.
Okay. Do we have any more discussion, or do we want to put it to a vote? I think we'll put it to a vote.
Yes being what?
Yeah, a yes being in favor of continuation to November 16th, and a no vote to look at another motion and more discussion. All right.
Yep. So the motion fails.
So we're on to another motion. Do we have another motion that we want to make tonight to have further discussion on this item?
I move to overturn staff's notice of determination concerning screening at 8,000 South Park Way based on the following. One, the non-conforming structure does not meet the reasons for termination under 10-10-2C2. And two, the PD supports parking and similar uses.
Second.
Okay, we have a second motion and a second. Now we'll open it for discussion on overturning staff's decision. Could you please just repeat those items that you cited as the reasoning?
The non-conforming structure does not meet the reasons for termination under 10-10-2C2. And that was on page 2 of the staff document. And my second point was that the PD supports parking and similar uses. So that being on Attachment B dated March 25 or 26, 1981, book 7604, page 275, and in paragraph 2, numbers 8 and 18.
Excuse me, I misplaced 275.
Member Primo, when the meeting is over, would you mind letting me copy that from you?
Yes.
If you have that written down? Thank you.
Motions?
I have it in here somewhere. Do we have further discussion?
You know, I tend to say it's not an error that's occurred. I know that got characterized as an error earlier. I think it's just a different interpretation that we're looking at. As I mentioned earlier, I did go to the site and I watched several cars come and go and people come and go through the security gate. I did drive around the other side, around the phone company side. I saw cars with license plates, cars with dealer plates, cars with little things hanging off the windows that presumably held keys or something. I'm not sure how that worked, but it was a very active area. I sat there for 15 minutes and saw probably a dozen cars in and out of there easily. I was a little taken back by the equipment. There's some big industrial equipment that I'm not sure how that's actually servicing that little building. I'm still not sure on that, and it's its own separate little fenced area that's different from the other car park section. I think I'd maybe characterize this as maybe a transfer facility as opposed to a storage facility where I'd see other things stored out there, for example, snow plows or some kind of equipment that's going to be sitting there until the next time something happens that they need it, and it's just going to sit there. From what I observed, all the cars were running and available, and from what I could observe. I don't think the use has significantly changed. It's always been a parking lot. It hasn't been enlarged or extended or different than it initially was designed and built. It's not available to the public, clearly by the gate and the key code to get in there. Again, there's a lot of people who had the codes to that. I saw a dozen cars go in and out of there, but everybody had to use the key code to get in. Is it a new use? No, I think they're parking cars there, not really. Yeah, not being available to the public as parking. I mean, it's parking, but I'd characterize it as parking. Again, as I saw cars drive in and out and come and go, and I couldn't say they can move all those cars. I don't know how many cars are in there, hundreds, presumably. But, of course, they're not all going to go at the same time. So that's some of my thoughts on this particular property.
Any other discussion? I have a few more things on here. I think while the code is maybe not as clear as it could be when it comes to the screening and the like of storage versus parking, I would agree that the use has not changed really significantly. It is parking. It sounds like there is intent to possibly redevelop it, or at least a portion of it, at which time they would go through the site plan process and be required to adhere to the zoning code as it's written. I think this property is unique in the fact that it's behind everything. It has no public frontage, really. It is behind the buildings. It's kind of back of house. It is visible from adjacent uses, but I think to that point, most of those adjacent uses are, again, back of house, parking. utilitarian uses for those businesses in that the Gates subdivision. I would note, though, that, you know, in review of the PD, you know, the permitted uses of, I guess what stood out to me in section 2, paragraph 2, under permitted use on, book 764, page 275, you know, parking of motor vehicles, I think the applicant made a good case that it is not specific to use by right. It doesn't specify if they're leased or if they're stored or if they're just there for a couple hours servicing the building. But in there, it also mentions under item 12, you know, warehousing of raw materials or finished goods. Cars could be considered finished goods, and they are transitioning, as Board Member McClintock mentioned. But then when you go further in, you get to page, book 7604, page 276, down under paragraph 8, item 8, it says paragraph 11 is amended in its entirety to read, and then there's A, temporary open storage of equipment or materials shall be as much as possible, considerable distance from the front, side, rear setbacks, and screened by fencing and or landscaping. I think this goes along with staff's argument about temporary storage. It is parking, but it is also, to some degree, temporary storage. And I think we get hung up on the semantics of that portion. But except in item B, it does mention, except as presently existing facilities and bulk storage tanks, all outdoor storage facilities shall be enclosed by a fence and or landscaping, which fully conceals such facilities from the adjacent properties, public rights of way, which doesn't really apply here, pedestrian ways, which also doesn't, and then be non-toxic, corrosive, inflammable, or explosive liquids. Those two paragraphs seem to lean towards the intent of what the code is mentioning with regards to screening from adjacent properties for a use like this, if you interpret the parking as storage and or temporary open storage. In the code section 749, with regards to derelict or unlicensed vehicles, under B, it does list commercial or industrial zone districts, fully enclosed structure, or in an area located behind the principal structure or screened from view from adjacent properties. I think we're meeting behind the structure. I think really the issue here is adjacent properties, and that's where we get into interpretation of similar uses or not. And I think I would argue that the uses are similar. I think historically it's been used as parking. It appears that maybe it was being used for leased storage, parking at that same time prior to the applicant taking over that space. I think because of the uniqueness of this situation, I don't know that we can really apply these sections of derelict or licensed vehicles, or, as you mentioned, the determination. I mean, there was really there's no change in the structure. It is not a non-conforming structure. There's no structure there. And the uses haven't really been terminated. It's a parking lot, and it's still a parking lot until the applicant goes through with the site development plan. So I guess I can see both sides of the argument. I think it's frustrating that this particular property, unfortunately, has kind of fallen in the cracks, so to speak, of the development code and just how it's been developed. And I guess I'm having a hard time applying what the staff's determination is versus the PDP, because I think the PDP allows it, but also does require screening. Regardless, and maybe that screening didn't happen, but in number 8, paragraph 11 as amended, it does not mention anything about new construction. It doesn't really even mention anything about change of use. It just says that open outdoor areas storing equipment and materials shall be screened by fencing and or landscaping. And I don't think we have that case here. So while I don't necessarily agree with staff's determination, I guess, on the arguments behind that, I would say the PDP is clear. There's the grandfathering factor as well that I think comes into it, where, you know, the fence is existing, the landscaping is existing, or non-existent, I guess. It would be up to us to determine that there was a change of use, I believe, in order to apply those standards. I think that's the only thing that would maybe be relevant in both cases.
I think one of the questions when we talk about the PDP and this Section 8, Paragraph 11 is amended in its entirety. In item B, depending on the age of the parking lot and the age of the PDP, it says except to presently existing facilities and bulk storage tanks. So presuming that the parking lot was presently existing when this was written. So to me, that would say new parking lots, new facilities, new items of that nature would fall into this category.
And this was done in 1994, I think is when this was recorded. Am I?
Recorded, but.
It says Exhibit A, it's got a stamp on the top of it. It says series of 1981, but then it has a stamp of 1994, July 22nd, on the top of page book 7604, page 272.
Are we talking about the PD?
Yes.
It looks to me like it was recorded in 1981 was when the resolution was originally passed.
And we don't have any documentation to say whether or not it was or was not. I think the exhibit we have was 93, right?
Right, the earlier photo, yeah.
Wherever it went here.
Exhibit B is
This
1981.
According to the first page of Exhibit, second page of Exhibit A, it was recorded on March 1981 at 7:30 p.m. was when the resolution which approved the PD was passed.
So I guess my question is, what is the date? It's really hard to read, but on the first page of Exhibit A, it says 94 June or July 22nd at 2:14.
That's from the Arapahoe County Clerk and Recorder's Office, it looks like. But the resolution was passed much earlier.
In 1981, okay. Do we have any more discussion? So the motion on the table right now is to reverse staff's determination to overturn staff's notice of determination concerning screening at 8,000 South Parkway based on the following. You mentioned 1010-2C2?
Would you like me to reread the whole
Yes,
thing?
please. Can you please restate the motion?
Sure. I move to overturn staff's notice of determination concerning screening at 8,000 South Park Way based on the following. 1, the nonconforming structure does not meet the reasons for termination under 10-10-2 C2. And 2, the PD supports parking and similar uses.
Okay. I guess, do we have a vote? So a vote for yes is to overturn staff's notice of determination, and no is to not. Good.
The vote is 4-1, and the motion carries.
All right. I think that closes our general business for this evening. Do we have any other comments from staff, public? Anybody else? No?
Thank you.
All right. Excuse me?
Sorry, no public comment, just on the agenda.
Comments, reports from community development staff, or
Staff
chair members?
and members.
Nope. All right, then we'll adjourn this meeting. Thank you.